private citizen's affidavit alleging two felony charges against Mr. Francis Forchione. Present in court is Mr. Conley on behalf of the applicant. Is that correct?
Yes, Your Honor.
Good morning, Mr. Conley. How are you?
Good morning, Your Honor.
And on behalf of the City of Canton Prosecutor's Office, we have a special prosecutor from Akron, Mr. Craig Morgan. Do you wish to be heard further? I know I've reviewed your memoranda, Mr. Conley, and I've reviewed the affidavit. Do you wish to be heard further?
Yes, Your Honor. Just briefly, would like to move for admission of Exhibits A and B, and I have filed certified copies of the two judgment entries with the court, one being the December 31, 2012 judgment entry of Judge Forchione, and the other a January 2, 2013 judgment entry of Judge Forchione.
Those were attached to your memoranda.
Yes, and if I may have those admitted for purposes of this hearing.
How about the check involved? Is that?
It's attached, Your Honor. What Judge Forchione did was to his January 2, 2013 judgment entry, he actually attached to his own filing the letter he wrote to the fund in Connecticut and the check itself, and that's all attached as part of the it's part of the record, yes. And the only thing I would add, in addition to the brief that I filed, is a quote from the Ohio Supreme Court in State v. Lozano, Lozano, 90 Ohio State 3rd 560. This was a theft in office case. A utility worker in Cleveland stole a few $100 worth of scrap water meters, was charged and convicted of a felony theft in office, and tried to argue it didn't really apply to him. The Supreme Court found that it did apply to him, and even though it was only a few $100, it was a felony. But the court at page 563 stated, when a public employee takes public property, it deprives the taxpayers of the state of Ohio of the value of that property, no matter how great or how small. And the court went on to say, in applying a statute, it is the duty of this court to give effect to the words used. And I would respectfully suggest the words of this statute plainly indicate a theft offense and also a theft offense in office. And although it's a somewhat unusual circumstance, my client had cited in his affidavit to the Adams case, Court of Appeals case, and in that case, a low-level clerk working in a motor vehicle office in the county of Cuyahoga declined to collect fine money, $5 a pop, 150 some times. She never got the money. It never went in her pocket. She didn't create a phony receipt. She didn't embezzle. She just didn't collect the money and did so without authority. She was convicted in front of a jury of felony theft in office, upheld by the Court of Appeals that found that's what the statute says. She deprived the owner of that money without the owner's consent. The potential defendant here, Francis Forchione, did exactly the same thing, but even more so, Your Honor, as evinced by that Exhibit B, Judge Forchione actually collected the fine money check and actually himself sent it out of state with a clear intent to deprive the owner of the use of that money. And I would respectfully suggest probable cause should be found. Thank you, Your Honor.
Thank you, Mr. Conley. Mr. Morgan, you wish to be heard?
Thank you, Your Honor. I guess a few things, and I think that the court is aware of some of this, but I think it's better if it's said so that Mr. Demas, although he's not here today, feels that everything has been done appropriately. I am here from the Akron Prosecutor's Office. I'm the Deputy Chief of the City of Akron Prosecutor's Office. I do not work for the Canton Prosecutor's Office or the Stark County Prosecutor's Office. I was asked to be here because I do not know any of the parties involved. I have never met Francis Forchione. I did get an opportunity to not only speak to Mr. Conley, but I have reviewed everything that I've been given relating to this case, all of the journal entries relating to the Studer case, which everything that we're here today is predicated upon. I've also reviewed all the memorandums. Your Honor, from the state's perspective, criminal law is, the act is so less insignificant compared to the intent. And the intent here, the culpable mental state is knowingly, which is the court is aware is the second highest standard that the state would have to prove. You know, we have strict liability, which is the absence of intent. We have negligence, we have recklessness, we have knowingly, and ultimately the highest degree we assign to anybody is purposefully. The same act, for instance, if we take causing the death of another, can relate in a multitude of different charges. It could be a misdemeanor of the second degree under strict liability for vehicular manslaughter. It could be reckless homicide or voluntary manslaughter if you act recklessly. And if you act with prior calculation, design, and purposefully, it could be aggravated murder. And I think that's the key here, is the intent. When I read theft, let me back up, Your Honor. It does not appear that the facts here in this situation, they're not really contested. The journal entries speak for themselves. What was done speaks for itself. The key for any prosecutor is whether or not we can prove the culpable mental state. My concern is that there's no evidence to suggest that the potential defendant here acted with a purpose to deprive. More importantly, that he acted knowingly, and I think that's the big key. Knowingly is being aware that your conduct is of a certain nature. Do I believe in reviewing everything I've reviewed that an error was made? I do, but do I believe that the potential defendant here acted knowingly in thinking that he was acting with purpose to deprive the Stark County Treasury of this money? I don't, Your Honor. I mean, it's clear that the case that this is predicated on, the Stewart case, it was a tragedy for the Stark County community. It was an individual who was in a position of public trust, who violated that position of trust, and he's going to spend 15 years in prison for doing that. The potential defendant in this case, he took that tragedy and tried to aid a national tragedy, which was the incident that took place where someone of true evil walked into a school and murdered a bunch of children in Newtown, Connecticut. I find that there was an error made here. I find a mistake was made here. But, Your Honor, I do not believe the state, myself, or any other prosecutor, even if we look at this as under the Criminal Rule 29 standard, looking at it in the light most favorable to the state, I don't believe there's going to be any evidence capable of allowing a rational trier of fact to find that the defendant acted knowingly in this case. And for that reason, we'd recommend no charge be filed.
The court will take this matter under advisement, re-review the affidavit, memoranda, and the arguments of counsel on the decisions.
Thank you.
Thank you, Your Honor.